conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who, facilitation to wit aggravated assault. Any person who commits the offense of facilitation to wit aggravated assault is guilty of the crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the aggravated assault. And that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Simple assault. Any person who commits a simple assault upon another is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant caused bodily injury to another and that the defendant acted either intentionally, knowingly, or recklessly. Facilitation to wit simple assault. Any person who commits the offense of facilitation to wit simple assault is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant knew that another person intended to commit the specific offense of simple assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the simple assault. And that the defendant furnished such assistance knowingly. Simple assault has been defined on page 18. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 3 in this indictment. Convicted felon in possession of a firearm. Any person having been convicted of one of certain specific felonies who possesses a firearm is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant had been convicted of a specified felony, and that the defendant, after such felony conviction, possessed a firearm, and that the defendant acted either intentionally, knowingly, or recklessly. Firearm means any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the results will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find from the proof that the defendant has been convicted of another crime or crimes than that for which he is presently on trial, you may not consider such evidence as proof of his disposition to commit the crime for which he is on trial. The defendant has pleaded not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all the evidence presented in this case by the state and by the defendant and give it full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified? In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or result of the offense, the defendant solicits, directs, aids, or attempt to aid another person to commit the offense. Intent means that the person acts intentionally with respect to the nature of the conduct or to the results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Absent material witness. When it is within the power of the state or the defendant to produce a witness who possesses peculiar knowledge concerning facts essential to that party's contention and who is available to one side at the exclusion of the other, and the party to whom the witness is available fails to call such witness, an inference arises that the testimony of such witness would have been unfavorable to the
Guilty.
side that should have called or refused.
Guilty, guilty, guilty.
Whether there was such a witness and whether such an inference has arisen is for you to decide, and if so, you are to determine what weight it shall be given. This inference does not apply to the defendant because he has a lawful right not to testify, and his failure to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulations. A stipulation is an agreement between the parties. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have entered into two stipulations. The parties have stipulated that Adolph Thornton Jr. was a living person who is now deceased, and an autopsy was performed to substantiate these facts. The parties have also stipulated to the fact that the defendant, Justin Johnson, is a convicted felon, previously convicted on May 2nd of 2017 in Division 8 of the Criminal Court of Shelby County. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community or leaving of the community or parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight. If flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Multiple counts, finding of each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. That is the law, ladies and gentlemen. We will now proceed with closing arguments.
Good morning.
Good morning.
So it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on this case. And earlier this week, you heard opening statements. You heard opening statements from prosecution and from the defense attorney. And you were told all the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts. Conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Corneliussmith. He testified for us and he told us that he met Justin Johnson through Hernandez Golan, and that he knew Justin was a rapper, and he was also known by the name of Straightdrop. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify defendant in open court, and during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting, facilitating, and, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is 1, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. 2nd, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. 3rd, you have to prove that the killing was premeditated. And as we saw, or as we learned in voir dire last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car, you held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children, she's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who is now deceased. Later on, we heard from Dr. Scantleberry. She was the medical examiner and performed the autopsy. She found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hawkins. he testified that he was head of Dolph Security for years. He was able to identify Dolph's car in the beginning of the MAKEDAS video, and he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was ADOLPH Thornton Jr. But was that killing
So in other words, he broke down the difference between CMG and PRE. They did not say a conflict between Big Juke and PRE. It says CMG. So does that put YOGOTTI in a conspiracy in the RICO? Absolutely.
He said,
hey Miguel,
on the day of the murder,
let's be clear.
The defendant picked him up from his father's house.
Let's keep listening.
They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Juke had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, CORNELIUSSMITH and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the MAKEDAS parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at MAKEDAS. CORNELIUSSMITH was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, CORNELIUSSMITH testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Juke. In that FaceTime call between Big Juke and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they received wound care. They change their clothes, and then they go their separate ways. After they go their separate ways, CORNELIUSSMITH tells us that he went to retrieve his phone, and he went to go wipe down the car, the white Mercedes that was parked at Bradley. So with CORNELIUSSMITH's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into MAKEDAS parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 21st to November 22nd, November 17th, 2021. Next, well actually, let me go back to Kissing Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride. And his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. .40 caliber, attributable to a handgun. .762, attributable to an assault rifle that Cornelius-Smith had. .223, attributable to a semi-automatic that Marcus Gordon probably would have had. And a 9mm casings found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the .40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from MAKEDAS and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartments at 10:49 a.m. that morning. The timestamps on Gospel Garden and MAKEDAS coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time that Kissing Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed a tower in the area of the 2-lane road in Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Officer or Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Kiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends the outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the defendant arrives in a white Ford Expedition. So the next thing, convicted felon in possession of a firearm. The 3 things that we have to prove beyond a reasonable doubt is that 1, this defendant was a convicted felon or convicted of a specified felony. And 2, after being convicted of a felony, this defendant possessed a firearm. And 3, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, 1, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of a felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelius-Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you've made? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all the stipulations, all the videos, all the photographs. And now it's time for you to consider that evidence and apply your common sense. And after you do that, I think, well actually I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams. Sir.
Thank you, Judge. It's good to see y'all again. This is the last time you're going to have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court, Mr. Hagerman, Ms. Iris, all of us agree that you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible, and the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. And on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper. Wanted to make it as a rapper. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley. You know, engaged in a music video, right, for his rap. Hat kicked to the side, kind of grin on his face, because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make, beyond a reasonable doubt, is the heaviest one. Maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have, and I'm sure you have. and not to talk about the case. You know, the thing that you've been listening to for days, with people all around you that have going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully. To listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like CORNELIUSSMITH, that conscience. Because I don't think he really meant that when you heard from him. He said, oh, the reason I decided to tell the truth is I got a conscience. And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He didn't. You've heard a lot of concepts, you know, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill ADOLPH Jr. He didn't conspire to kill ADOLPH Jr. And he wasn't the man holding the pistol in the MAKEDAS video. And it's going to be up to you to decide that. To watch those videos. Watch them closely. If you want to talk about those videos, I encourage you to study. Give them a close look.
It's open and shut.
The state doesn't
It's
want to
justice for
acknowledge
Dolph.
what I told you in opening, and that is similar.
It's open and shut. What's the delay? Guilty. But let's listen.
Why could he? And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro Act. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it, other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson, and said that person always wore a Bass Pro hat. You have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments, you look back at the MAKEDAS video, those are the same underwear. Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore. And I agree. Right? You know, we've got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics. Right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelius-Smith said he wiped it. And you guys, we'll get to whether you believe that or not in a minute, okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelius-Smith. There was DNA found. One of it coming back to Trayon Ingram, right? Not Justin Johnson. Now, there's a lot of talk about gloves, right? They made a big point to say, you see gloves in the video. Now, they want you to believe that Mr. Johnson's running around in this Mercedes, and the reason that his prints aren't on it are because he's wearing gloves. And mind you, Cornelius-Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think, he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go in the crosstown and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building, or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel when they're doing crosstown, and when I asked it, I think it was Detective or Sergeant Dabney, about there was surely other cars going in and out at this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen, that Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told me. And if you recall, Mr. Hagerman had to kind of go back at him, and I think he said something like, I can't tell you that, and then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly, he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas, and goes, that's not me in the video. And he's like, okay, it's me. But they're trying to tell you Justin Johnson's at the Valero gas station, right, when he's pumping gas. Where is he? Now, they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson. And that he was the other passenger in the Infiniti, but you can't really make out who he is. You have to rely on Kristen Garner. That's what you have to rely on. And we talked a little bit about, proof beyond a reasonable doubt. And I said one of the ways that you could used to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle. The same one described as being held by CORNELIUSSMITH in the shooting of ADOLPH Thornton Jr. Their prints are in the car. He says they have, what he said, a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediately, day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be? And B, why couldn't he just say, oh, I can't anything to do with this? And at Valero, you do see Trayon and Kristen. They're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, with a phone using, a tower that could be and he said could be, he said was in the service area of the Valero gas station, or then he said, I didn't do any drive testing, so I can't say what the coverage area would have been, right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit, you'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small, they're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time immediately after ADOLPH Thornton Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction, the other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important. When there are a group of fine people that are looking to find the truth and have to make this decision and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3-mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know I don't know, the next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened, and he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this. There was no evidence at all that Justin Johnson was present for any meetings discussing this hit. What Corneliussmith said was he met with Hernandez-Govan and Jook, and Justin Johnson was not there. And then he said he met with Hernandez-Govan and others on another occasion to discuss it, and Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you, probably all of you have had to talk to somebody before and go, are they telling me the truth or not? And that's exactly what's here. But accomplice testimony is flagged because that person may have an interest in the outcome of this case. And you go, what is that interest? Well, Corneliussmith, number one, told him. You know, he had to admit, he didn't want to admit it, but he's meeting with the state. He's hoping to get a benefit on his own sentence. He's supposed to be telling the truth. But he's writing his sisters at the exact same time that he's meeting with the government, or the state rather, and telling them, I didn't do this, I'm just lying to get the deal. I'm just lying to get the deal. Now, is that his conscience, like he wanted to say? No. That's him telling his family. Why would he lie to his sisters? If he had a conscience, right? If he had done this out of the sense of, I did this awful thing, I feel awful, I've got to accept responsibility and tell the truth. No. But you remember, and it was kind of an interesting moment when he was testifying, because at one point he says, oh, that's not lying, I was gaming. Gaming's not lying. And the unfortunate part of all this is he's gaming everybody, including trying to game y'all. That's the problem. And he thinks he's going to walk. I mean, and the only person in this case who got paid for this. Remember, there is no proof whatsoever that Justin Johnson got a penny. Cornelius-Smith got 50 grand for a lawyer for killing Adolph Thornton and didn't have to give it back. He didn't have to give it back. His lawyer was in the courtroom. And I asked him, I said, you remember, I said, how could you? You didn't give it back, you grew a conscience. What's going on with you? And he went, well, I did it. Services rendered, right? And the lawyer, he's talking about with his sisters, he's saying, oh, well, my lawyer's telling me to cooperate. I'm walking. I'm not doing it unless I can walk. Now, he was asked by Mr. Hagerman, have I ever told you? Have I ever told you you're not going to have to go to prison? And he said, no, you've not. You haven't. But you have to keep in mind two things, right? At the time he was giving all this information that made him valuable to come in here and talk, he thought he was getting out. That's when those letters are going out. Those letters are going out, and he thinks he's getting out because he's got the lawyer, they got the cooperator from Holly Bobo to walk. And that's the type of thing you have to remember when you're assessing whether you can rely upon Cornelius-Smith and anything that he said. The guy that sat in that chair, and he was asked by Mr. Hagerman, when you killed Adolph Thornton, what did you feel? And like it was nothing, said, I didn't feel anything. Let's try to get paid. And that's the guy that they want to put in front of you and say, believe it. You know, he went and talked about exchanging money, right? Getting $800, right? At one point said, do you find people that he got that Mr. Johnson somehow came back into town and he talked on the phone with him and brought $500, and then some other time some other guy in a Chrysler 300 showed up and provided money to his girlfriend. Well, two things. One, that's not what Mr. Smith originally said to law enforcement. He said that Chrysler 300 came twice, and then Mr. Justin Johnson wasn't anywhere in sight. Well, and what do you know about the Chrysler 300? Jamarcus Johnson, right? Did Jamarcus Johnson say when he was here in front of you, did you ever hear the state ask him, did you deliver the money? As part of you being involved in helping Mr. Johnson, did you deliver money for him? I mean, he asked about the email, or the text rather, about Cornelius emailing Justin's phone and saying, essentially, I need money for the birthday party. That's because Cornelius-Smith is lying from start to finish. And then for the first time ever, here in court, he says he wiped the card out. Who's in contact? Who's in contact with Govan? According to Mr. Smith. Mr. Smith. Who's not in contact with Govan? Mr. Johnson. Did you hear anything about that? Now, when you go back in the jury room, you're going to be reviewing, obviously, these videos. And one of the things that you have to kind of ask yourself is timing. When you see Mr. Johnson in the elevator with his little girl leaving Crosstown that morning. And of course, you know there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then of course Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time. And put an officer on the stand, the lieutenant, to talk about getting access to the time, how he got the timestamp. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp one in. That seems like the logical choice. But then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. Had to have a technician, it's a computer. I don't understand it, but when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and time. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelius-Smith. They got to leave, then turn around and go to Bradley and go back to the white truck, right? And then get out and be in front of the Makeda cookie at 12:21. Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other? Right? Takes longer, right? If you're stopping places, if you got to park, if you're presumably dropping a child off, there's going to be some kind of a exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. And all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that according to Cornelius-Smith, should have been captured on Hernandez-Govan's home security system. Right? He said Govan had a security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember, he texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. You know, he didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez-Govan. All right? We don't necessarily know if they did or didn't, because we didn't get to hear from Mr. Govan. You know, I asked the Detective Browning if he was aware of any video from there. No. But if Cornelius-Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22, when he was meeting with law enforcement. And you know, I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called by the state that wasn't called. Hernandez-Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right, for you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in voir dire, about getting two people to talk to kind of differentiate. You know, some of you that may have been a teacher, talking about that is one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez-Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement, which meant he was allowed to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does. I don't have the ability to wave a magic wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion. He's to Mr. Johnson's exclusion, and ultimately to your exclusion. And if this is a truth-seeking function, why didn't the state call him? And it is. Your job is to find the truth of the matter. And ultimately to go, did they prove their case or not? But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is as important as any of them. And the law states that it creates an inference that the testimony of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, can you really render a verdict of guilty and have your mind rest easy? And not walk away and go, I just don't know if I did the right thing. Knowing that there was information out there that could have been presented to you and wasn't, that would have been favorable to Mr. Johnson, that I couldn't give you. Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and CORNELIUSSMITH, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other videos and what you didn't hear? The answer is no. When you examine your conscience after you've taken the time to deliberate, I think you'll find the answer is no. Two things I want you to remember, and I'm wrapping up. The way the burden of proof works. You've heard the statement, right? They ain't got nothing to prove. You may say that to somebody. I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here. They do. And we've all heard the term benefit of the doubt. Right? Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. Again, I appreciate it. This is, as I said, last time I get to speak to you. The state's going to get one more opportunity to talk to you this morning. They get the last word. That's how the system's set up. But it has been my honor to represent Mr. Johnson in this case, and it's been my honor to present this case before you all. And thank you so much.
I've been calling him Luke all this time. His name Lance.
He started this with a little Memphis talk. Those cookies are fire. I think that's how we started it. Little more Memphis talk. What y'all
That's Texas.
even
Y'all is
talking
Texas.
about? What y'all even talking about? A missing witness? Hernandez Gomez? A missing witness? Hernandez Gomez?
They gonna wear his ass out.
Absent material witness. And the defense wants to say that is Hernandez Gomez? What do we know about Hernandez Gomez? He's a defendant in the case. He is charged with murder and conspiracy to murder. Whether it's from television or whether it's in black and white at the bottom of that same instruction, a defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here, testify. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, actually what they used to call it, where you didn't have that right not to come to the courtroom. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe it? Or look at CORNELIUSSMITH. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's called. So don't believe him. So I made a mistake on one slide about the time, so it was corrected. So we can't believe the video. You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kirsten Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car, and they're trading it with her buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Bolero video, which shows something strange. Shows something strange. Shows Kirsten come up in the car and somebody else get in and drive off. Strange. Another little piece of corroboration, where's Justin Johnson's phone at the time? Well, in the area of the Bolero station. Can you say it's in the parking lot? No, you can't. But it's in the Bolero, in the vicinity of the Bolero station. But my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Bolero video. We just don't have a hate report video. We don't just have a crosstown video. We don't just have a defendant who's like, Smith, I'm guilty and so is he, that's us two in the parking lot shooting them. We got Justin Johnson's actual phone. We got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the MAKEDAS shooting, and as soon as you see the video of Crosstown of him leaving in the exact same outfit, in the white Mercedes, case is over. But we keep going. As soon as you hear from a codependent who's like, that's me in the parking lot shooting dog, I'm going to prison, and Justin Johnson's the guy next to me doing it, case is over. As soon as you see the Haven Court video, 40 minutes after the shooting, of the two shooters and his cousin, case is over. But then things kept on happening. But if you didn't have all that proof, it would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we had a text. The night before the homicide, we had a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of the white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Kissed and said. They met on Bradley. Then they drove to Valera. And they switched cars. That's corroboration. So do you have to be willing to trust Kissinger with the keys to your car? Of course not. You think I trust Kissinger with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because it's on video of Valera. It's documented in his phone with literal pictures and locations. This is plain and simple. Do I have to believe that Cornelius-Smith is talking because of pains of conscience? No. No. He's talking because he got caught. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like Kissinger's, that we can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I miss a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius-Smith from him right before he comes and picks him up at LILMIGO. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, real tricky truth test. Justin's driving the white Mercedes. You see it in the video, of course, when he testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway there on the front. Well, we know the white Expedition is also Justin's car. We've seen it across town for testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called the 2 Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? Well, why expedition? Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Corneliussmith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Corneliussmith driving and Justin in the passenger seat, just like it had to happen, just like Corneliussmith told you when he testified. We do the shooting, Justin's driving a white Mercedes, he hands me the keys to the Expedition, we get to Bradley, I jump out, I get in the driver's seat of the Expedition, Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in the Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax come, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the two pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we can try this. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments when this trial was just over again for the 5th time was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and then FaceTimes with somebody. He says it's been a joke. The guy that put the money down for this. Number 2 is CMG. The guy that put hits on the other artists too. Cornelius says it's a FaceTime. Spelling out dolph with your hands. And what do we find in Justin's phone? I mean, delete the stuff all day long. He did. Whole day. You know, Brimstone said, delete it all day long, but it's still in there. A call and FaceTime interaction with him. Justin Johnson with Big Joe. Look at Joe. Cornelius tells you. And there you see it in black and white. It's not 1981, that's true. Call on camera and everything else, but you're also walking around your pocket with a phone that you can delete a call on, but it's still there. The times you called Corneliussmith that morning, still there. The time when you called and then FaceTime with Big Joe right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Did he have enough time to do it? He didn't have enough time to do it. He left crossing at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes. Total trip probably take you 30 or 40 minutes. Yeah, you have enough time to do it. We saw him do it. Memphis talked all the times. All the times. Before the murder, we see him at Crosstown in the murder outfit. Similar clothing? No. Identical clothing. Patch on the legs, Bass Pro hat, everything. Before the murder. The Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. during the murder? Again, caught on video, white Mercedes, back end damage, the exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you calling? Who you texting? Big Joe. Caught before, caught during, and then caught after. At Haven Court. Video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He is literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we have? Another Memphis phrase. Get on down. Get on down. Across town, the last video. Packing my suitcases to head out of town. Packing my suitcases to head out of town and get on down. Like the police tell us, on manhunt. Not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down. The crime has been committed, Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down. Flight can create an inference of guilt. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at Crosstown with the suitcases leaving, knowing that the manhunt was coming and he was out of town and leaving. Real guilty. Real guilty. Now it's time for us, though. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding. We don't get on down with pictures of Rolls Royces, stacks of money. We get on down by doing what's right and doing our jobs and looking at the evidence, the witnesses, the corroboration, and applying the law to those things. We get on down by doing justice. We get on down by saying you are called all the times. You are called all the times and you're guilty of all the things. Conspiracy to commit murder? I just heard, okay, let's at least cut him a break on the conspiracy to commit murder because man, he wasn't there for at least like one of these meetings with Big Joe or something. That's what I just heard. Let's cut him a little break on the conspiracy to murder because he's not at this meeting with, Big Joe and Govan and Cornelius. So let's cut a little break on that. That's what I heard. Let's cut a little break on that. There's no requirement in the law that every conspirator have to be at every single meeting with each other. There has to be an agreement and an understanding. And there was clearly an understanding. Big Jook is going to pay money to take out PRE artists, and at the top of that chain is Dolph. Now, does he demonstrate any understanding of that? Is there anything he does that shows he's part of this understanding that this is going to happen? Yeah. He literally shows up with gloves and guns, has a white Mercedes he gets from Treon, has Cornelius driving next to him, and they drive and go do it. So the idea that, okay, he committed the murder, but give him a break and leave that, he's guilty of the conspiracy just like they're all guilty of the conspiracy. And of course he's guilty of the murder because we watched it on video. Last short thing. Just one minute. Just one there. You too real. Dolph, you too real. He rapped about what he calls calm. What he saw in the evidence, what he saw in his family, growing up. Too real. He rapped about people that he had a rivalry with. Too real. Dolph, too real. Included distance of dangerous people like Big Chuck. You're too real. Too real. Too real. Last moments of his life, last seconds of his life. How long does the video take? 30 seconds? You're too real. Dies on the floor in the neighborhood cookie store in Orange Mountain. You're too real. Your family misses you. Erica and Nina, the kids. You too real. This is real.
Hey, exclusive illest blame game, Big Juke.
And when the killer wanted to,
He was confident. He been confident the whole time. Shabi,
all the times,
from the very beginning.
we even watch him get on down. It's time for us
Oh well, yeah,
to be real.
and they gonna wear. I'm gonna tell y'all now, they gonna wear Go Van ass out.
No, we don't need Memphis talk for that. It's called Just Do What's Right.
They gonna wear Go Van ass all the way out. So now the blame gonna be on Go Van since Juke is gone and he don't want to give up Gotti.
Anita Smith and Justin Johnson killed ADOLPH Jr. November
See that?
17th. We watched it happen. Anita Smith, Justin Johnson, Mendes, Govan, Big Judd, they all conspired to have it done. And it was done. November 17th, 2021. And as he did it, he was already a convicted felon. He should be found guilty of all counts. We do what's right. That's how we do. Guilty conspiracy to commit murder, murder in the first degree, and convicted felon in possession of a handgun.
I got a few more pages of the charge to read to you. I'm gonna pick up on page 29. charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder. When you retire to consider your verdict in the first count of the indictment, you will...
Hold on.
All counts. You do what's right.
Guilty.
Verdicts. Count 1. The charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least charged and included in count 1. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder, as charged and included in count 1 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offense as charged and included in the first count of the indictment under the law defined and explained to you, it is your duty to acquit him. The verdict will be: we, the jury, find the defendant not guilty as to count 1. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. You will next inquire whether the defendant is guilty of first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, second-degree murder, as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of second-degree murder as charged and included in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, facilitation to wit, first-degree murder, as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, find the defendant guilty of facilitation to wit, first-degree murder, as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least, as set forth on the previous page. If you find the defendant guilty of a lesser included offense, your verdict will be: we, the jury, find the defendant guilty of, as included in count 2 of the indictment. Insert the lesser offense in the blank. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the second count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: we, the jury, found the defendant not guilty as to count 2. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 3. The charged offense in the third count of the indictment is convicted felon in possession of a firearm. There are no lesser included offenses. You will next inquire whether the defendant is guilty of convicted felon in possession of a firearm as charged in the third count of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: We, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment. If upon all the proof, you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the 3rd count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be, we, the jury, find the defendant not guilty as to count 3. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict on a particular count, the foreperson will write your verdict as to each count on the outside of the jacket and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. All right, as I told you before, this is the official copy. Please refer to it. There's just been a couple of minor changes made, but nothing substantial, nothing substantive. Let's put it that way. A few typos I ran into, but other than that, please use yours, make notes on yours, refer to yours. But this is the official copy if there's any discrepancy. The jacket, please. You will have all of the exhibits will go back with you. Please look them over. If at some point you want to watch videos, please let us know. You have did you make the list? Okay, is it?
It's been numbered as an exhibit, Your Honor.
Okay, so it's with the exhibits. You have a clean laptop, so they can you get us a clean laptop so they can watch videos as they want to watch videos? Thank you. So you will be provided a laptop that's clean, so you can watch videos how you want to watch videos, and there will be a list accompanying the video to show you, to tell you, describe to you which video is which. That makes sense? So, is everybody in good shape to deliberate? You've been ready to choose alternates. Everybody good to deliberate? I'm going to call three numbers. Once all three are called, the deputy will escort you back to the back to get your belongings. And then if the three of you could come back out here, because I have a few remarks for you. And then the rest of the jurors, the 12 of you that will be seated to deliberate, will go back and begin your deliberation. Okay. Juror number 18. Juror number 13. Juror number 12. like, you can review these.
Oh, yes,
That's what I said.
Oh, no.
Just always. Really. Just make it a point to show you.
Yes, Your Honor. Thank you.
Lunch should be here in a little while. Let me admonish you now. All 12 of you will deliberate at the same time. There should never be an opportunity where 2 or 3 over there eating and the rest of you are deliberating. If you decide you're going to eat, everybody eat. If you decide you're going to take a break, everybody take a break. When it's time to deliberate, everybody deliberate. Just let the deputy know that you're doing something different besides deliberating. Okay?
What's your verdict? What's the verdict? It's open and shut. AunTeaFee, what? So we just gonna sit here and act like this ain't open and shut. It's justice for Dolph. It's clear cut. What's the problem? We popping bottles tonight? Let me see if I got a bottle. Are we popping bottles tonight? Tea sippers. Woo! Let me see if I got. Baby, when I tell you it's been down here for a minute, don't judge my New Year's Eve champagne. It ain't no Cristal. No, is that the name? But we. Let me set them down. Hold on. Leticia. We popping bottles. Ain't that what they say? Hey, Courtney. Ain't that what they say? Vacation across the country. Ain't that what they say? We popping bottles. What they say? We popping bottles tonight, baby. downhill. It's a wrap. It's over and done. But the heartache live on inside. The heartache that y'all took this man's life for no reason at all, other than jealousy and greed and money. Couldn't measure up, so you have to take him out. Can't compete, so you kill. Is that what you're telling me? Justice for Dolph, baby. AunTeaFee, you got your hat on. Yes, indeed. What's going on? It's justice for Dolph. It's by any means necessary. It's justice for Dolph. And they gonna wear, when I tell you what they was gonna do to Big Juke, know why they let him, I know why. Okay, I'm gonna stop saying why they let him stay on them streets. And they knew he was involved with the hit, with the delivering. Well, hell, he didn't even deliver the money. He did. I was about to say delivering of the bag, but hell, he didn't even do that. He was finna hustle them out their money, and then be anonymous in directing the police to go look for their white expedition. Yeah, they was finna hustle their asses. Cause why he didn't pay them their money? So what they was gonna do to Juke in due time, they gonna do to quit. Cause he didn't take the stand. Him mad. He what, AunTeaFee? Him mad that they didn't continue to let him play on them streets. And while he was out there playing, when they had that meeting, that pre-trial conference, they brought more evidence and told him, oh, well, AunTeaFee saw your ass out on the corner where they was fighting and shooting. It was on the news, and she spotted you right off. You wasn't supposed to be there. You were supposed to be in the house. Then you got stopped in South Haven. You were supposed to be in the house. So all of what they let your ass get away with before, again, I tell y'all, it's not a problem until it's a problem. I told y'all that. They gonna let you do what you do. They gonna act like they don't see it. They gonna turn a blind eye until that ass get caught, until you get in trouble. And then they gonna say, oh, well, you knew the terms and the conditions. And then you gonna say, but you, and they gonna soulfully pop your ass. They go, baby, you knew the terms and the conditions that you signed on the dotted line. We was just gonna let you do what you do, follow your ass to see where you was gonna go. And then throw it back up in your face at our convenience. And they gonna nab that ass. Because they was clear. He was clear. He was clear when he said, as long as you tell the truth. And give us what we need, we'll work out a deal with you. So your slick ass, your bet with quit ass, thought that you could set this up with old big dookie Juke. Beat these people, these hitmen out their money. Make a deal to get out of jail. Like you gonna help them out. Hey, Gemini. And then lie. Continue to operate. Continue to sell drugs. Continue to order hits. continue to have the human trafficking. Did you say human trafficking, AunTeaFee? Oh, y'all think that ain't gonna eventually come up in a RICO? Oh, y'all think that they not gonna dangle that type of shit? That's why him mad. Cause they're gonna pop. They're gonna pop. Him mad cause he thought he was gonna get a get out of jail free card in that pre-trial conference. And he found that they done created more evidence against him where all the deals are off the table. Cause Juke gone, you can't bring us Gotti. What you got? What else you got? There go that ghetto look. What? What else you got? Cause that right there ain't that ain't enough. What else you got? We got some evidence. We need something that we ain't already got. We need CMG. We need Gotti. Name him. And then you got a deal. Hello. You can't name him. Oh, you can't name him. You can't put a wire on. You can't wear a cap with some. You can't do shit. Oh, boo. Then they start moving all like, oh shit. Oh, boo. Life. You ain't got nothing else. You ain't got nothing else. So that's what you call when a player get played. That's what I call when you get beat at your own game. See, that's when that gank, AunTeaFee gang come out. They played you. They beat you at your own game. Oh, you thought you was slick and they slicker. Oh, okay, my bad. I thought you was the shit, man. They pump your monkey ass up like you just the beginning and the end, the alpha and omega, like you God of Orange Mound, Nick. They say those shit go on in the mound without you. You mean you ain't got nothing that's gonna save yourself this time? You mean all them other times where you done slid with your partners in the homie with the criminal activity, but somehow or another, you always managed to slide that ass out and push their asses up under the bus. You mean to tell me, Slicky Wicky, you ain't got nothing to give them to save yourself this time? So now you say you're not going to even go on the stand. You ain't going to help at all. You gave us the finger? Then we going to make you fuck yourself with your own finger. Hello. That's what's coming, y'all. So they couldn't get Juke. They do have enough to get Gotti on a conspiracy with a RICO, boo. You can't say y'all you don't know him. You can't say you ain't cool. You was cool enough with him that you sit Art Horn, your homie, your whole family, your whole organization attorney. So you was cool enough with little homie, little bro, that you sent Horn to represent him. Until the nigga wouldn't follow directions and turn himself in. Cause Art was clear, you know, we gonna see what's happened once he turned himself in, as he had instructed. You instructed him as his counsel to turn himself in. And then you'll be able to do what you do. But the mere fact that the nigga don't listen, he hard-headed, Art Horn said, oh, now let me moonwalk back. This right here gonna be a problem. And he gonna be the reason why the whole organization gonna crumble. So let me moonwalk back out and let him handle his own business, because the way he moving, I'm gonna have to represent you against him. Come on, y'all. So Gotti can't act like he don't know who Straightdrop is. He would, because he said if he turn himself in, if they catch him, he gonna burn him out. He said, get home however you can. After things done went on for a minute, but just don't snitch. And he looked at him, and then he walked off. He did this on his IG. And then Art Horn said, pump your brakes, partner. Stop communicating. They picking up on your body language that you talking, that you sending cryptic messages to Straightdrop. And then he cut it off. Well, bye. Damn girl, I'd walk off from you too. Who walked off from me? Don't hate. Don't hate. Don't be mad at me. Hey, Lisa W. Like a clear windshield. Uh-huh. Mm-hmm. Mally, go on somewhere, cause you want to play. I don't even want to play with you today. I don't even want to play with you today. You ugly. And you funky. You smell like shit. Go on. Y'all say bye to Cayenne, Mick, whatever his name is. Mally. Go on. I ain't got time for that. What's up, Carolina? It's justice for dog. I don't even feel like playing with him. They deliberating. They shouldn't be deliberating long. It's cut and dry. I'd be like, oh, I'm trying to eat. It's lunchtime. This is what I would be saying if I was back there deliberating. Oh, guilty. I don't need to see no video. I was paying attention when trial was going on. Guilty. Come on now. How much they paying us for tonight? If we can leave, we can get paid for the whole day. Yo, they done got him in the same funky clothes for 3 days. They got his accomplice. Hey, Willie Spencer. But what we talking about? Guilty. Can we go home now? How we gonna get back to Nashville? This is what I'll be in there saying. Who gonna take us home? Who paying for the hotel? Did we check out tonight? Can I go check out? Can we stop and get some barbecue before we go though? See, that's what I'll be up in there cutting up saying. Boo, what did you see? You didn't see what I saw? He was driving the car, the getaway car. Hell, that in itself is enough. Then he got out with a gun. What else? And he wasn't supposed to have one. Then he aimed and shot. What we doing? The guy that was standing next to him done already told on him. How did we even know that he FaceTimed Big Juke? Cause he told us. And then we collaborated that with the towers. The towers done went all in their business. Told us where you was when you FaceTimed and told us somewhere that you had a 3-way conversation. There was 2 or 3 of y'all on the phone. You also done told us that your mama tried to tell her that she done had a spirit come over her saying that you messing up your life and you refused to answer your mama's call. What else we need? Huh? You had your little baby. Hell, if your baby, the love of your child, didn't say, no, I don't want to mess up nothing because I want to see my child. Hell, you had her with, you put her ass in danger, driving around in a stolen damn car and shit. You know you had beef and shit in the street. Oh, you really didn't have beef in the street. You was just a hit man. Is that what you're telling me? Mm-hmm. What else? Then you done involved your cousin, a hopper, in a conspiracy when they do a RICO. She done made calls for you. She done called a Sears for you. He done brought you some bandages and shit for his bullet holes. Y'all wiping each other down with peroxide and shit. What else you need? Can I go eat now? They used them back. Robin, act like they was finna come up off 100K and you got 800 fucking dollars. You guilty. And you had the nerve to have, well, I guess you did. I guess somebody did not give you your money. But did he? Hell, you act like you wasn't there. You act like you wasn't a part of it. So what was you telling? So what your brother get involved for? If you acting like you wasn't there, that wasn't you in them funky ass clothes. Well, who did your brother see? See was Cornelius and trying to call Unc because you needed some money for the birthday. Well, hell, what you have your brother playing like he was you for? If it wasn't you, reckon you could have answered your own phone? So what you involve your brother who didn't have a record, ain't never been in trouble, had never been in jail before? Crash dummy specialist. So why did you, if it wasn't you, why your brother involved? Why your brother say, yeah, them the same funky ass clothes he had when he brought me his phones and shit. He knew I needed a car, so he dangled a car in my face. So he used me too. What else you need? So nigga done made me a convicted criminal and shit. Yeah, that was him. C, and there is an Unc somewhere, cause C ain't Unc and C ain't Juke, cause he done already said that Juke was Juke in his phone. So again, who is Unc? Cause it ain't C and it ain't Juke. It ain't Quit. Don't play. It's more to come. It just have to come out later, baby. It's gonna be a part 2, part 3. Big RVA, nutter. You can't see my hand. I got my arm up. Hey, yeah, don't play. Don't play. So what we deliberating for? Are they back? Let's see. They should be back. Again, I should have been second arm, and I need to be in the deliberation room. I'd be like, what? Do I need to recap you for? Can't recap you. What we need to see a film for? Didn't you see him in the elevator? Didn't you see him driving the Benz? Didn't you see his funky ass get out and point the gun? 20 minutes left until, what we waiting for? Hell, I could be eating. Ain't it lunchtime? I'm hungry. Hell, and with their asses off the street, maybe we could walk down Bill Street before y'all take me back home. Because y'all take me back to Nashville. I don't know when Go Van turn is. Hell, he was supposed to start Monday. But they still got the Scorpion unit going on. Now they crying. I did it for, and how in the, I don't want to talk about that because we're going to pick up after that afterwards. But Mims now talking about he has a special need child. And you have the nerve to be beating a black man knowing that you black. Knowing you got kids that somebody can very well do a mistaken identity and beat the Y'all still ain't been able to give the people a reason why y'all targeting him, because y'all don't want to say the real. But now, because there's so much going on, mistaken identity, you know. Now y'all don't even want to show these people faces. These are criminals. Why y'all protecting criminals? Because somebody gonna tag that ass in prison? Well, didn't they tag somebody's ass on the streets? Didn't they kill somebody on the streets? So you mean to tell me you want to protect their asses? Because they life in danger. Wasn't Dolph life in danger? Memphis is, something in they fucking water. I thought I wanted to visit. it's just something in the water. Y'all protected criminals. Were they? I bet not ever get in trouble. Hey, reflections. Black, I must say how wild. No, you not finna do that. You done lost your mind, wild. Get your ass on with that stupid shit. Y'all say bye to wild. Did he lose his mind up in here? What type of shit? Thank you, Kimberly. We do not accept racism in here. Only people can say that is us. And I don't know you one of us. So we gonna get your ass up out of here. Real quick, fast and hairy like. For Laquita come in and clown your monkey ass. Okay? Y'all see I ain't got none of my hair on. I'm in one of them cap on, hair slick back, pop them earrings off mood. And we popping bottles tonight. What's his name? Wild Archery. Don't make me bust this bottle over your head. I got a whole champagne bottle right there. Cause we gonna pop bottles tonight. Oh yeah, we gonna skip to the loo, my darling. Let me... Y'all know how long we been dealing with this? We gonna dust that ass. Letitia, we gonna dust that ass. Let me go check and see what they doing. Let's go see. Are they back? Oh, was this morning? Oh, that was this morning. Let me go see what they doing, y'all. Oh, yeah, he ain't got nothing. Let's go in here. We popping bottles, baby. We popping bottles tonight. Oop. We might as well, we popping bottles tonight. What else is on? We popping bottles tonight, baby. Hey, Tara. I'm trying to see what else is popping. Oh, they gonna play. They gonna wear Orange Mountain Quit ass out. Push this back. And I can't wait. Hey. I'm trying to see who's talking. You popping bottles, baby. Big Will, what it do? It's a wrap. And they finna I hope. Where is CMG Cookie Monster game? I know they asses mad that Luke, I kept calling him Lance. Luke done added them. Now they need to go put him in hiding for a minute, because he was a part of Walk Down Gang, or he's affiliated with Walk Down Gang, and he's cool. They was cool with Trula, so he knew good and that's why I kept saying, people was wondering, well, AunTeaFee, why you keep saying something about the guy in the back? Because I knew for her to sit there and say there didn't nobody in the cookie place that was working there that day, didn't nobody know Straightdrop. I already knew that was a lie, because I knew who he was affiliated with. So because she was playing dumb to the fact that didn't nobody know Straightdrop, made me say, well, where he at? Why he ain't made a statement? Y'all remember I kept saying that. Well, where he at? Why can't nobody question him? Is he a witness? What? Because AunTeaFee know who he affiliated with. And I know what those, the combination of the two affiliations do for a living. Now, he may be trying to change his life and he working in a cookie spot. Right? But where he at? So that's why when they would say the cookie people did this, no. My only concern is MAURICEHILL Jr. Where he at? Where he at? Is he a witness? What he know? You mean to tell me he ain't gonna, if he's affiliated with a gang, he know what goes on in Memphis? His brother is Cotto, you know, he done been in and out. He done, so where he at? You mean to tell me he affiliated with Walk Down Gang? And we have heard Straightdrop say that on more than one occasion in his little rap. You mean to tell me he ain't run out? He ain't say nothing? He ain't do nothing? He ain't gave a statement? Oh, now they don't know Straightdrop. They don't know nobody involved. And I knew she was lying. Hey, Kawana. I knew she was lying. Now you saying, well, he wasn't involved. Girl, you said he didn't know him. So don't gaslight it now. Don't move the goalpost. You said he did not know him. So at that point, I knew that you was lying again. I knew that I had caught you in a lie again. So for them people to come in there saying, I owe the cookie people an apology. No, I don't. For what? What I said was true. He did know him. And he ID'd him. So you lied when you didn't have to say nothing at all. But you can't keep your mouth shut. So as far as I'm concerned, you and Luke, Luke Evans, put your cousin life in danger. Luke, as far as I'm concerned, with the streets, who's for Straightdrop, okay? Because he said somebody at the cookie shop, a guy, not the girl, a guy, a fella, ID'd him, said he always have on a Bass Pro hat. So if something happens to him, it'll be because of him. Right? She lied when she just could have kept her mouth shut. So after the recess is when he would get his charges. Well, no, he's already been charged. He'll get the verdict. They are deliberating, guilty or not guilty. For you to envy. Hey. When they come back, they will be given the verdict. Guilty as charged. All the proof they have, they better come back with guilty. Yeah, Byron, double guilty. Mm-hmm. Mm-hmm. And I will confirm when in the comments when, hey Kevin, how long is this? It's not recess, they're deliberating. So the jury is deliberating. The prosecutor, he arrested yesterday. And they sat back after hours and determined how they was going to word the charges, which charges that she was going to read to the witnesses and explain it to them. You know, they kind of did wordplay, negotiation on the code. One is less than the other. They did that shit last night after hours. So when they started with her breaking down what they talked about last night behind the scenes. But on the scene, because, you know, we saw it. And then Luke gave his closing, you know. And then Hageman gave his. They broke it down. Y'all missed that, so the defense didn't put on a case? Well, he put on his case when he did the cross-examination. That was the trial. When one spoke and then... so you said that he didn't put on no witnesses. Is that what you're saying? Is that what you're asking, Kimberly? So the defense didn't bring up no witnesses on behalf of Straightdrop, where he tried to. He tried to get Drop to defend himself. And he said, no, will do. I'm not going to defend myself. We're going to let the chips fall where they might. So, case when they started, they have the defense rest. Who was he going to bring? Who was he gonna bring? When they started doing all this stuff right here, let me show y'all. It was real cut and dry. After the longest part of this morning was her going over, you know.
We have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant,
this is the longest
all
part.
offenses charged and included in that count.
You shall. When they started putting those blue screens up.
A reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts. Conspiracy to commit first-degree murder, and convicted felon in possession of a firearm.
So what they dropped was the car. Was the carjacking in the stolen car, because what happened is that they putting that on Trayon now and Tristan. So y'all remember when they had that 10,000 to 60,000, they removed that because they did not steal the white Benz. Okay. So that's why he got those 3 charges.
And especially through the jury instruction.
So when they start doing this stuff right here,
a conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder.
What's the second one?
2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, so Smith had known the
facts and analysis
for a couple of months. And they hung out a couple of times before the murder. He was able to identify defendant in open court, and during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit
it's
on
sad
Dolph.
they have failed
Cornelius said
attempt
that he and Justin agreed
and
to
getting
kill
taken
Dolph
out by two
together,
goofies.
and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson.
So when they started doing this type of stuff, it was a wrap.
So there we have it.
Did you see this,
A
Kimberly?
conspiracy to commit first-degree murder.
And who
An agreement
else?
was
Come
made.
on. Great
Each of
content.
the
Watch
parties had
from
the intent
Chicago.
to
Thank
commit
you,
the first-degree
TY.
murder.
Thank you, everybody.
Each person acted for the purposes of promoting, facilitating, and, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of
It was
another.
definitely premeditated.
What's required for first-degree murder is, one, that the defendant unlawfully killed the victim.
Rest in peace, young
The only
dog.
way required for first-degree murder is, one, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. Second, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake. There was no accident.
It was not an accident. It was
Third,
definitely
you have
on
to prove that
purpose.
the killing was premeditated. And as we saw, or as we learned in War Dyer last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car. You held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next. So we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children, she's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who is now deceased. Later on, we heard from Dr. Scantleberry. She was the medical examiner and performed the autopsy.
Lord,
She found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon.
so he did not have a gun on him.
And we also heard from Raul Hopkins. He testified that he was head of Dolph security for years. He was able to identify Dolph's car in the beginning of the MAKEDAS video. And he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? Back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing.
It's cut and dry. He spelled out Dolph.
That on the day of the murder, the
Hey, Deborah
defendant picked
Franklin.
him up
He's
from his
nervous,
father's
ain't
house.
he? He worse than
They
nervous.
both knew
He know
that
it's
the
a
victim was
wrap.
doing a turkey drive with several
Oh,
of
I
his
don't know.
PRE artists.
Let me go to
They
another one to
also
see
knew
if they back.
the Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's
Let
car.
me make sure they not back.
Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the MAKEDAS parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at MAKEDAS. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video.
No, they're not
The
back
second
yet.
suspect that got in the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius-Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Joe. In that FaceTime call between Big Joe and our defendant spelled out the word golf. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they receive wound care. They change their clothes, and then they go their separate ways. After they go their separate ways, Cornelius-Smith tells us that he went to retrieve his phone, and he went to go wipe down the car. The white Mercedes that was parked at Bradley.
So it was 9 white women, 1 black man. It's 9 white women, 1 black man, 1 black woman, 2 black men.
Cornelius Smith's testimony.
Hold on.
We have established that the killing was unlawful. There was no evidence to show
Raymond,
that this defendant was in fear.
Okay, you know what? I'm gonna tell you why I ain't scared no more.
Or was protecting someone else.
It was 9 white women, 1 black woman, and 2 black men. Them 9 white women ain't gonna let Ted ass off free.
And then shoot them. We also established that it was premeditated. They knew about this hit beforehand.
Do y'all agree?
And they committed this hit.
9 white women.
So if that wasn't enough for you, we heard from somebody.
1 black woman.
We heard from Kissing
2 black men.
He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kissing Gardner was at the Valero gas station in the early hours of November 17th, 2021.
Nope, it's a wrap.
Next, well actually, let me go back to Kissing Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or that a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride. And his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone. He fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney.
Y'all
He
think
was able to tell us about the 4 different
raising
bullet casings that were
flags
present
during the closing argument?
.40 caliber, attributable to a handgun. 7.62, attributable to an assault rifle that Cornelius Smith had. 2.23, attributable to a semi-automatic that Marcus Thornton.
Closing arguments.
And
The flags that he brought up.
Or 9mm casings found inside the store, which could be attributable
Surveillance
to the
video
handgun
timestamp.
that Marcus Thornton
That
had
was
inside
not
the
enough.
store.
No DNA found on the car.
Attributable to a handgun was in the hand
He had
of
on
the suspect
gloves.
with the Bass Pro hat.
None of his belongings.
So, Sergeant
None of the
Dabney
belongings
also
belong to
recovered
Straightdrop.
from MAKEDAS and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartments at 10:49 a.m. that morning.
Since there's no video
The timestamps
evidence of
on
Justin
Gospel Gardens
Johnson
and
being
MAKEDAS
in the white
coincide with
Mercedes.
the times defendant's phone
Well,
accessed those
whether we
towers.
saw him in it, we
We
saw his
heard
ass
from
hop
Special
out
Agent
and
Garner,
shooting.
who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time, the Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And
Do
it
y'all
accessed
think
those
them
towers
9
during the
women,
times of the murder, 12:22 p.m. to
one black,
12:23 p.m. on November 17th.
2 black men, you
Garner
think
also explained
they gonna let him off?
phone accessed the tower in the area of the 2-lane road
No.
in Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Officer or Sergeant Dabney identified the defendant being present for.
No.
So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Kiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends the outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the defendant arrives in a white Ford Expedition.
Let me put some juice.
So the next thing, convicted felon in possession of a firearm. The 3 things that we have to prove beyond a reasonable doubt is that 1, this defendant was a convicted felon or convicted of a specified felony. And 2, after being convicted of a felony, this defendant possessed a firearm.
We know
And
that.
3, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, 1, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of a felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Corneliussmith, who verified that the person in that Bass Pro hat was Justin Johnson. And that
Yeah, if he would have answered his mama's call, he probably would have.
So based on all of that,
yeah,
we can see
I
that
agree.
we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you've made? My instinct says yes. And once you've had time to deliberate, I think yours will too.
So y'all, what I'm gonna do is charge up my phone, wait for them to deliberate, come back once they finna start the deliberation. All right, y'all hit y'all like button, like, share, subscribe, and make sure you hit the bell to get the notification.
And apply your common sense.
Or y'all want me to let it continue to play? What y'all want me to do? You want me to stop, or do you want me to let it just play?
You will find this defendant guilty on all
Okay, you saying bye. Which? So y'all want me to end it, or just let it play?
Thank you, Judge.
Let me charge up, y'all. Let it play, let it play. Okay. You caught me.
It's good to see y'all again. This is the last time you're going to have to hear from me.
I'm going to let it play.
And as I see all of your faces,